aka joint pain. Incorrect push-up form here. Today's episode is brought to you by serious boredom and also exam season. So today's episode is about in the continuation of how rebellion is establishment or recognition of autonomy. Money is the certificate of autonomy and law is the checkpoint of autonomy. That's what I tried to do with this episode. And the reading for this episode is significantly more bland than before. I am extremely disheartened to let you know that the first reading I have for you is a textbook. It's a AC or AP Achyutan Pillai's Jurisprudence and Legal Theory textbook published by EBC. I think it should be very easy to find for all of you. The reprint is made in 2019. You can find it in almost any academic bookstore or online on the web store for EBC. The second one I have is one of my favorites, a book that I always wanted to talk about on the podcast called Beyond Good and Evil by Friedrich Nietzsche. The third book I have for you is The World of the Homosexuals by Shakuntala Devi, an interesting read. A good read for all of you people who are interested in intersectional understanding of the queer world. The book after that I have appearing on our list for the second time in the span of 3 episodes, but is an important one. I heavily recommend that you go through it. It's The Hero of Two Worlds by Marquis de Lafayette in the Age of Revolution. A Hero of Two Worlds is the name of the book, and it's by Mike Duncan. The rest of the reading for this episode is frankly, it's case laws, and I'm going to mention the citations of these cases down below if you want to go check out the case documents by themselves. And they're pretty popular cases, so I don't think you'll have trouble finding original copies of court documents for these. The first one, of course, is Keshav Nanda Bharti versus the Union of India, which is the one that establishes basic structure of the constitution. Most of you must be familiar with this. It's single-handedly the most famous case in the country. After that, we're talking about AIDS Bhedbhav Virodhi Andolan versus NCT of Delhi, then the Nas Foundation versus NCT of Delhi, then Sushil Kumar Kaushal versus Nas Foundation and others, and finally Navtej Singh Johar versus Union of India. I tried to keep this episode a sort of like a lesson in legal theory or explorations in philosophical literature followed by examples in history that we need to cover and explain my point through that. I hope it works for you, and I'm gonna cue the fucking... Any bit of content that tries to explain something as abstract and as wide as the concept of law, especially in the context of law as in a checkpoint of autonomy, which is what is the point that I'm trying to convey through this episode. And I assure you, I will be taking an excruciatingly long time to come to my point. I believe this episode should start with an easily recognizable definition. And the reason I say easily recognized is because anybody who is academically studying law or has semi-academically flirted with the idea of studying law must have come across a definition given by a certain gentleman named Jeremy Bentham. Jeremy Bentham's definition's appeal is very simple because it summarizes the entire thing in a sentence that's lesser than a line, which is pretty well explorable. At least it's a good place to start learning law, according to me. The definition mentions that law is nothing but the command of the sovereign backed by sanction, and we will unpack that definition over the course of this episode and see why it's not the best version of the definition today to understand law, but it's a good place to start understanding where law comes from. Jeremy Bentham, of course, being a positivist, gave a positivist definition, and it's the best way to reduce the entire positivist school of thought into a sentence. Positivist school of thought, when it comes to thinking about law, very clearly states that they do not think of law as a divine entity or something that's already there. It is a very much social construct according to the positivist school of thought, which means that it recognizes that authority within human society comes either from the absurdity of human existence or from man-made trades or man-made constructs. And we explore law with this definition that We appoint a sovereign. The sovereign is the one that we give power to, and he uses that power along with sanction to implement law and give order to society. The positivist definition of law does not exist in a vacuum. It exists in response to another theory, which is something that we believed for the longest time. And if, in fact, it's something that interjects with the positivist school of thought later on in this episode, but we'll get to that when we get there. But it's a response to another massive school of thinking when it comes to thinking about law in general, which is the naturalist way of thinking about law. Naturalist way of thinking about law is nothing but the natural order articulated by man but given by God. Essentially, naturalist order assumes that there is a higher power of nature or God is how natural powers have always been summarized in the past literature, which is why I use those things in the same way, but they're not necessarily the same under most readings. The only thing common between reading nature and reading God is, of course, the fact that it states that there is a higher power out there which dictates the law. It is the job of the human to articulate the said dictation of nature into law. Now, under some cultures and under some religions, eventually as society progresses, that nature becomes God, and the divine definition, which is the order of things given to man by God, takes up the naturalist definitions of law. Which brings me the most important part of the definition of law, which is sovereign. Whether or not you adhere by naturalist definition or a positivist definition, you know that law essentially is implemented by somebody, and the sovereign is the somebody. Now, how is a sovereign selected? Depending on which theory that you adhere to, it will vary a little bit. For example, naturalist definition, which eventually led into the divine interpretation of the naturalist order, sort of gave us monarchy. And we've explored this before, knowingly or unknowingly, within an episode about Egyptian mythology. I think it's called A Guide to Justifying a Monarchy in Egyptian mythology, somewhere in the 90s of the episodes. For those of you who have heard the episode, please pardon my repetition, but I must repeat for people who don't listen to all of it. I assume way too much of that. Anyway, basically in that episode, we discovered how the sun god Ra was used as an excuse by the monarchy of the Egyptian civilization as an excuse to justify their rule. The pharaohs of the Egyptian civilization in their time either very literally believed or spent a lot of money and time letting their subjects believe that they were the descendants of the gods that they worship. They were the descendants of the sun, and that gives them the right to lead everyone else. And it's an important discussion because a lot of the monarchs that you will come across in history, they spend a significant amount of time justifying their rule as sanctioned by God or chosen by God. There's a reason why the monarchy and the church were so close in almost all kingdoms of Europe over however long the monarchy had lasted in Europe, at least functionally. And the reason for that is because they needed the church to justify, the clergy needed to justify the monarchy. And the monarchy needed to protect the clergy. It was a power cycle loop. Almost all of it falls apart during the French Revolution. At least the cracks in it seem to show during the French Revolution. And don't worry, I'm not going to go again into the French Revolution again. We've done that in episode 101. Please go check that out if you'd like. No pressure though. But during the course of French Revolution, there was a significant amount of Enlightenment literature that was created by philosophers in this time, which disputed this entire notion of the natural order appointing a sovereign. Instead, they came up with the idea of human rights. In a very pleasant surprise, it's a good way to join episode 101 with episode 103, because the Declaration of Human Rights, like the Declaration of Man and of the Citizen, which is cited to be declared in 1789, was drafted by Marquis Lafayette, an individual who was not only a key player within the French Revolution but also in the American independence. And it is said that the Declaration of Rights of Man and of the Citizen were made in consultation with Thomas Jefferson at the time. I'm pretty sure most of you would be familiar with the concept of human rights. It's very similar. Instead of saying that the natural order of things or the divine order of things is not that the sovereign must be appointed king or a sovereign is supposed to lead people to glory, but to say that every individual that is born is given certain rights by the virtue of being human. This declaration, of course, went on to be a very consequential part of international jurisprudence in human rights and is actually a direct source in the 1948 Universal Declaration of Human Rights made by the United Nations. And the declaration is recognized by all signatory countries. But at the same time, we have to understand that the French Revolution comes after something that is a much more logistical approach to this entire exercise, which is the American War of Independence against the British. The Declaration of Independence, which is a preceding document to the Declaration of Human Rights, takes a fundamentally different approach when it comes to the declaration. Of course, it recognizes the higher power because it is 1776 after all, but it has positivist elements in the sense that it separates church and state. The separation of church and state was agreed upon in principle by all the drafters of the Constitution in 1776, but it was not put down until the First Amendment of the Constitution until 1791, which stated that the Congress can make no law about the worship of the church, and vice versa, which is what implemented separation of church and state to prevent the rise of monarchy. Rule of law and positivist elements within the state structure were important to the United States government to exist as a democracy, which is why God-given rights were recognized, but God's interference within governance was not. I know I've jumped the gun a little bit when it comes to explaining legal theory's role within explaining a democracy, but we're about to deal with it right now because we're going to talk about social contract theory. And those of you who are cringing or face palming because I keep talking about it, it is that important, unfortunately, which is why it keeps coming up. And even if I wanted to avoid it, well, I would never want to avoid it. Trust me, I talk about it at every chance I get. But even if I wanted to ignore it, I couldn't because it's not possible. I think it explains society way too well. For those of you who have heard the last episode, you would know. Social contract theory basically means that all the individuals living within society agree to not do certain things to each other like they would do in a contract by the way of passing a legislation and appointing a sovereign or appointing a state to look after the conductance of the contract, sort of like a trustee or a treasurer. And hence democracy is justified because the transactional nature of society is finally recognized by someone. Of course, there are theories about the divine contract that would come across in the French Revolution, and the divine nature of human rights will also be recognized in all of them and all of that. But also, we finally recognize that society at the end of the day is a transaction that all of us agree to. And a lot of that will change through First World War because an incredible amount of violence, a godless amount of violence for a Europe that has never seen 80 million people dead before, will change those things. It will change the way God is seen. It will change the way religion is seen. It will change the way the glory of a government is seen. And the reason that matters is because it finally solidifies that the divine has less and less and less cultural role in the affairs of the state. And hence a democracy sort of justifies itself through the advent of technology, through the advent of the way affairs are dealt with, and social contract theory being a prelude to all of that forms an excellent basis for such a system to be justified. And in this system, of course, law of the land, which is criminal law, civil law, or the Constitution in general, which recognizes your rights, forms and it becomes sort of your prima facie document for a social contract. This is something that you are birthed into to agree. Your caretakers are agreeers to this contract, and until you are of age of consent to the contract, which you will have to sign, you will have no choice really. If you want to enjoy the benefits of society anyway, It promises you the benefits of society for your own self-improvement in exchange for compliance with rules and some taxes, of course. But what essentially a democracy also means is that the state, it becomes a coagulation of all our autonomies, all our monies that we can't access as an individual, but as a collective, we appoint an authority to pay out our collected resources to do things on our behalf. These things include a varied amount of things. For example, possessing an army that is capable of incredible amounts of violence, or dispersing education amongst children so that they can become qualificatory occupation holders within the economy, or providing subsidies to agriculture, providing subsidies to education providers, things like that. You get the idea. But with that supposition comes an important social norm, which is that the law, along with the social conscience itself, must seek the truth, and it must seek the social good. In fact, what we refer to as the greater good and the greater evil will come to be referred as the greater good, as in the good for the society in general, and the greater evil as in something that is harmful or unfavorable for the larger society in general. Hence, in this context, law essentially becomes a tool of collective governance sanctioned by an appointed authority to ensure individual progress, but always in the light of protecting the greater good for the benefit of the society. I did come up with that. Please quote me on that. If it turns out to be useful, please don't quote me as an idiot. Do not popularize that opinion to criticize me. Please, all praises only. My self-esteem is very fragile at this point in time. And I better hear you laugh at that joke, okay? Important. But getting back to the point, the reason I bring up the dichotomy between good and evil is because the exploration that we're about to do is from a very popular book, a very misunderstood book, and a difficult to understand book called Beyond Good and Evil, which is essentially a legal commentary by a certain individual named Friedrich Nietzsche, which I don't think is recognized enough or taught enough within any schools, really, at least the ones that I went to. If your teachers teach that, that's pretty cool, and to be honest, I feel like it's an interesting read. As you can probably assume, the first time I read it was around when I was 18, maybe actually not 18, I was 20, and I didn't understand a word of it because it was so contextual to the works of other philosophers that it was impossible to understand. And I understood it later because I googled it and I read about the book itself. And those of you who are about to read Nietzsche, or just starting to read Nietzsche, or intending to read Nietzsche, I would suggest not to start with Good and Evil. Start with something like Thus Spake Zarathustra or something like that. Do not start with Good and Evil because it is a profoundly confusing book. It's got tons of context behind it. Imagine that you were born in 2020 and in 2040 you heard an entire anthology of a rapper from 1990s diss tracks, and you have no idea who these people are or why they're being criticized. That's exactly good and evil. It's a list of criticisms of all the philosophers who've come before him. But that's not to suggest that the book itself does not have any content on its own. Of course it does, at least in the later bits. And of course the book is heavily influential on contemporary philosophy because of the reasons that we'll explore now. But then again, you will find me saying that about every Friedrich Nietzsche book because there's so many philosophers in like the 20th century that mention Nietzsche as one of their primary inspirations to write philosophy. The point being, Friedrich Nietzsche's book essentially questions the dichotomy between good and evil with a very simple list of questions that has been coming through from the Socratic method. He asks why. Why is it necessary to prioritize the social good instead of the individual good, or the indifferent universal good? And more pertinent questions being, this was a time when the Enlightenment philosophy was extremely popular. This was just after the Enlightenment age. We were just implementing these ideas into regular life. And hence, questioning these ideas became very important for Friedrich Nietzsche. Not only because he was distrustful of Enlightenment philosophy, and also because he did not believe it to be a perfect philosophy, but then again, this was a time when we believed that an objective truth was achievable with the senses we possess. And essentially, these are the kind of questionings that Friedrich Nietzsche pens down in this book. For example, one of his favorite disses made in the book is against René Descartes. He spends a lot of time within the book dismissing René Descartes' stuff. And René Descartes at the time was known for doubting everything that we came from. That was sort of his thing. And his doubting sort of led to his most popular quote, which is, "I think, therefore I am." Friedrich Nietzsche said that this is a preposterously assumptive statement. This statement presupposes the existence of you. It also presupposes the fact that you are the one who's doing the act of thinking, and it also presupposes that the thoughts authentically belong to you. According to Friedrich Nietzsche, and I am not joking, the logical conclusion of the inquisitions and investigations that René Descartes does through his philosophical thought and experiments should have been, "There are thoughts." End of sentence. And besides the extremely hilarious trolling, at least to me it's hilarious, I don't know about everybody else, but besides the trolling, I believe he's getting at a much higher point. He says that being human, or what comes with the human condition, is an unfortunate list of biases which are inescapable. Of course, this was the Enlightenment age. This was just when we were trying to understand being self-aware. We were trying to understand prioritizing science and knowledge and trying to find the objective truth. But it also means it was significantly easier to not be self-aware while doing that process. Friedrich Nietzsche's observation when it comes to studying other philosophers or writing about other philosophers in this book is essentially that there is a list of assumptions, there's a list of presuppositions that these philosophers make, and a lot of their life experience, a lot of their biases, a lot of what they come from influences the way they think, the way they articulate things. And essentially, any person who claims that they have been objective or they have been completely prejudice-less in the assessment of truth or their search of truth is not telling you the truth. Of course, through the book, I could sense that Friedrich Nietzsche in his book did not intend to suggest that they did not make an honest attempt to be without bias, but he did point out that these biases were inalienable to most of these men, and that if they told you that these biases had been alienated, it is unlikely at best and untrue at the worst. And while I understand that this is a significantly distant tangent to our discussion about autonomy and law, the explanation for these biases is what's more interesting, because he universalizes this criticism against philosophers to other institutions like religion and the state. He essentially says that the truth is unattainable, the truth is undiscoverable to a certain degree, and what the individuals do is not find the truth, but instead what they do is they conquer the truth. This again is a repetition, not a big repetition, but a slight repetition of something he says in The Uses and Abuses of History, an essay on which I based another one of my episodes on, I think episode 96 or something like that. And I believe it's a message that is resonated in a lot of the postmodernist philosophy that we've come to read, at least to me, through Foucault or through any other person that you've come to read so far. This is not to suggest that I understand postmodernist philosophy or how to classify it. It's a word that I just throw around because everybody else does. But so far my understanding of postmodernism is press X for doubt. The end. And yes, back to Nietzsche. Essentially what he says is that all law is the conquering of truth and dictation of truth by the winner of history. And he suggests that one must not only be wary of the intent of the sovereign or the intent of the treasurer or the trustee of law, but also recognize that there is a personal vested interest in carving the truth of a situation to be told in the future. Now, this is where the educative bit about the book ends, and his opinion, I mean, not to say that anything that we discussed so far wasn't his opinion, but his opinion sort of takes over to be the overbearing factor from this point onwards. Friedrich Nietzsche doesn't explain all of this only through the example of government, but also through the example of Christianity and what he calls slave morality. This is something that we've dealt with in terms of conceptual clarity, that any government or any power operates through the threat of violence, which is what we refer to as sanction in Bentham's definition, or even with the one that I came up with a few minutes ago. But in his example of slave morality, what he says is that what's at the base of any human experience and human expression is envy. He essentially argues that the slave morality essentially means when you can't fight the sanction imposed by the power of violence by an outside power, such as the Romans, for example, you make up a certain world where you have the power by criminalizing a certain aspect of life. For example, leaving behind greed or leaving behind pride or the seven sins, really. That's the argument that he makes anyway. And saying that hedonism is bad because that's something you can't enjoy right now because it's supposed to be reserved for the next life. This belief in a higher power, this belief in the afterlife, is essentially the slave morality according to Nietzsche. And what he essentially suggests is that the people that will come after him will be the free-spirited. They won't be the slave moral. They won't be bound by the same institutions as his people in his time are. Essentially, this is where he gives birth to the idea of the Übermensch. This is where he gives birth to the idea of the free spirit and the future of philosophy, and also where things go horribly wrong without his intention. Again, this is a flashback to the episode 101 of the Deep Fried Neurons podcast. We've discussed this in brief. His sister was a raging anti-Semite, and his literature became popular only after he died after 12 tragic years of mental instability. And his books were read by a certain Adolf Hitler, who put himself in charge of leading the country as a free spirit. At least from what's evident of the historical records, it is very clear that Adolf Hitler saw himself to be an extremely free spirit who is rebelling against the slave morality and rescuing the world from it, and at the same time imposing the God-given right of leadership of the German people. And at least to the best of my knowledge, I can at least say that the conversation about positivist definitions of law have indeed been treated alongside with the example of Nazism, that this is what positivist philosophy did. This is what the death of God in the reading of morality, in the reading of creating these legal sanctions did. It put a godless man in charge of a country and of the threat of the violence of an army, and about 6 to 9 million Jewish people paid for it, along with everybody else who was involved in the war. And to be fair, they kind of have a point, because if you look at some of the laws passed by the Nazi Germany during their time, it is horrendous to even hear about it. In September 1935, there were the Nuremberg laws passed by the Chancellor of Germany as one of the first acts that they ever did as an administrative being for the social benefit of the country. One of the legal provisions introduced by the Nuremberg laws was, of course, that any person who was not of a German descent by ethnicity was not a German anymore, which essentially made all the Jewish people residing within Germany as not the German Jews, but the Jews in Germany. And along with that, they passed the Defense of German Blood and Honor law within the same charter, which basically criminalized the marriage of non-Jewish Germans to Jewish Germans, or non-Jewish Germans to Jews in Germany. A side note, for legal purposes, do not draw parallels of these laws with any country that you're residing in, including mine, specifically for legal reasons. Thank you. But then again, I have to admit that Bentham's model is a very reductionist approach to applying Bentham's definition. It is a very literal interpretation in that sense. The command of the sovereign backed by sanction. It essentially makes any goon who can impose sanction by the threat of violence as the law of the land, which basically means any government that could come along and hijack the threat of violence and overthrow any checks or balances in the constitution could probably become the law of the land, which is the positivist approach to law. And essentially, all those who do not have the means to revolt against this law become the subjects, and either they comply or they die to the violent threat. In the case of Nazi Germany, this is very well illustrated because the courts that were prosecuting people during the time of Nazi Germany were the People's Court and not the courts built under the constitutional framework. Essentially, it was a hostile government takeover by a parallel government that bred inside Germany and to make it Nazi Germany. And that brings me to the most important factor of the way we practice law today, which is the rule of law. The reason somebody like Adolf Hitler and his National Socialist Party could manipulate the law into, whatever they wanted it to be, for like an open discrimination law, for example, is because there was no rule of law in that land. I mean, take for example our own federal structure of government. There is an executive body which does not have the authorization to do whatever it wants. There is a legislative body which has the authorization to make the law but not implement the law as they want. And the Supreme Court, which is supposed to be like the judiciary in general, which is supposed to be the guardian of the Constitution, which means that they have the authority to interject and settle any conflict in the implementation of law or act as the overseeing implementer of the Constitution in general, which basically means the duty of the Supreme Court is to ensure that the rule of law prevails. And of course, that doesn't mean that Supreme Court does not enjoy a sort of monopoly over declaring what truth is. Of course, Supreme Court holds what is the law of the land. It can review its own word on what is the law of the land, but it holds the autonomy over the final say over this discussion altogether. Article 129, 215, 144 and 141 ensure that the Court of Records, that is the Supreme Court under Article 129, and 215, which is the Court of Record in the form of High Court, can prosecute an individual for not obeying the court. And Article 144 ensures that all executive systems comply with the court to ensure its will, which means, of course, it's a threat of violence that the Supreme Court holds by itself, which is essential for the rule of law to ever prevail. Or, it could be the International Court of Justice, because it won't have an executive body to ever execute its commands. But essentially, this rule of law, along with the process of reaching the truth through the rule of law, but at the same time enjoying this monopoly over what is rule of law and how it is implemented, it creates this checkpoint of autonomy of the individual that we are talking about right now. Essentially, the point of rule of law is that an individual should get the entire and ample opportunity to explore his own or her own or their own development. But at the same time, rule of law also means that exploration of opportunity should not infringe on other people's rights or go against the public good as maintained by the public morale in general. This is usually decided by a very limited number of sources of law. Usually the primary one would be customs, which means something that's just law because it's been happening for as long as anybody can remember. Other times it's compliance with justice, equity and good conscience of something, which leads the court to decide in the ways that they do. But essentially, my observation is what it creates the room for something that we don't battle efficiently enough in this system is, of course, harassment through process or harassment in the duration of process. But then again, the problem arises because of a purely logistical issue within the legal system. This is not to suggest that theoretically we're all completely sound, but it definitely means that the logistical problems are much higher and much harder to solve than the theoretical problems if they arrive. Theoretical questions, of course, will be issues or questions of law that will be presented in front of the law, but not necessarily the logistics of how justice must be dispensed within the system of the court. And to illustrate my point via an example, I want to take the example of the decriminalization of homosexuality under Section 377. And it is going to be a slightly long one, so I would suggest that you strap in, and it's a contemporary history lesson for most of us. If you don't know what it is, if you're a law student, I am assuming under most circumstances you would know how this legal proceeding went by. If you don't, just like listen, it's completely fine. For those of you who are outside the jurisdiction of India or don't pertain to India or any of the colonial countries, Section 377 of the Indian Penal Code, or any penal code that was implemented by a British colony in Southeast Asia, relates to offences relating to unnatural acts. Under the British jurisprudence, from the time when the British were ruling inside India during the colonial period, the definition of unnatural offences under Section 377 very much included homosexual acts of sex, which in particular involves oral sex, anal sex, any kind of penetration that's beside vaginal and for the intents and purposes of reproduction. It is also worth noting that homophobia is a colonial import. There are temples in the middle of Madhya Pradesh, I believe in the Chhatarpur district. I'm not sure the name of the district. The place is Khajuraho, of course, as most Indians would know, depict homosexual acts within the sculptures of the temple. Temples vary all kinds of sexual acts across the spectrum. And they were built by the Chandela dynasty, or at least thought to be built by the Chandela dynasty between 1100 and 1400 AD, long before the British arrived. Hence, homophobia is a definite colonial import, and if not a colonial import as a culture, definitely a colonial import as a legislation. Not to mention, Britain themselves decriminalized interactions between individuals which were homosexual in nature as a crime in 1967. However, the legal conversation around this issue will not start till 1994. But before we get to that, I do need to address something rather important within the LGBTQIA+ space, especially being this Pride month. Happy Pride, by the way, everyone. Before we go on to the battle of Section 377, I do need to address the issue of trans rights, which is something that is always glossed over in this discussion, but it is extremely important. However, I am not going into the details of trans rights activism and the movement, besides the fact of stating that 1994 is the year that transgendered individuals get voting rights under the Indian Constitution, which is a fundamental right denied to them until that point. As for the other important precedents and legal developments when it comes to transgender individuals, I highly recommend checking out the Instagram feed of Dr. Trinetra Haldar Gamaraju. She is a trans rights activist along with a doctor. She has a highlight reel / highlight story section in her Instagram, which I found extremely informative, and of course she has a locus standi and an understanding of legal proceedings along with the medical procedures as well. From her experience, and she's done a brilliant job of making that accessible. So I highly recommend that you go check that out. Not to mention the new transgender bill that's out since 2019 is horribly discriminatory and invasive on transgendered individuals, and I don't want to deal with the complexities of it within this episode about the broad topic of law in general. And also because I don't have the locus standi for the community, and I'd rather have it be represented by somebody who is from the community. However, the developments within the Section 377 battle are over, and it is legal history for all of us to study. And the battles lying ahead are about the acceptance of same-sex marriage at this point. So, before we start the story, we need to know the initiating point of the story, which is AIDS Bhedbhav Virodhi Andolan. For people who don't speak Hindi, AIDS Bhedbhav Virodhi Andolan translates to AIDS discrimination prevention movement or protest. And these people came to the scene, and their primary fame was acquired in 1989 when they worked with the police to provide condoms to sex workers within red light district areas of cities. Their work as an NGO was elemental in curbing the spread of AIDS within the country and reducing the impact of the pandemic at least. And they were forced to go to the Delhi High Court in 1994 because of a very peculiar reason. It's because it had come to the attention of the AIDS Bedbhav Virodhi Andolan that there was an outbreak of AIDS within the Tihar jail campus. Tihar jail, for those of you who don't know, is one of the biggest central jails within India. And we've all seen movies and heard stories about what happens within jail, which is rape. But God forbid some of it is consensual. Or a lot of it is consensual, whichever reason. The AIDS Bedbhav Virodhi Andolan wanted to circulate condoms within Tihar jail. And Kiran Kher, who was the jailer at the time, denied them permission to do so because they would be endorsing a crime within the jail. Kiran Kher also, I must mention, has a United Nations award or a medal for peacekeeping, which came in 2005, about 10 years after this incident. But nonetheless, AIDS Bhedbhav Virodhi Andolan went to the court, could not follow up the petition, and in 2001 the petition was dismissed within the Delhi High Court. But the same year, the Nas Foundation took it upon themselves to continue the legal fight within the court, and they filed a public interest litigation within the Delhi High Court to declare Section 377 as void and against the Constitution. The case went on for another 8 years, and in 2009, the Delhi High Court, in the landmark judgment of Nas Foundation versus Government of NCT Delhi, declared that it is a fundamental rights violation against the people of the LGBTQIA+ community to list their sexual interaction under the unnatural offenses if it's consensual. And hence, they put consensual homosexual sexual interaction outside the purview of Section 377. However, this of course had a very scandalous reaction within the Indian community, and a certain astrologer based in Delhi named Suresh Kumar Kaushal went to the Supreme Court the same year, and the Supreme Court listened to this individual and said there is not enough evidence to suggest there is a significant number of LGBTQIA+ individuals residing within the country, and there is no explicit evidence of this community existent within the country in a sizable number for their rights to be protected or being oppressed because of this law. Hence, in 2013, Suresh Kumar Kaushal versus Nas Foundation and others reversed the judgment of the Nas Foundation versus Government of NCT and Delhi, and homosexuality was a crime again under Section 377 for a while. Then in 2017, a hearing was done about the right of privacy being a fundamental right. And for those of you who don't know about Keshavananda Bharti versus the Union of India, it's a landmark judgment. I won't go into the details of that now. We'll go into the details of this case much later. It's an important judgment, by the way. It establishes the basic structure of the Constitution, which basically means that there is an essential set of conditions that we agreed upon as a society when this nation began, which is non-negotiable and non-changeable by any amendment, by any government, under any circumstances, which basically protects rule of law, fundamental rights, and things like that. And fundamental rights, of course, being an important part of that. And one of the things that must be read into the fundamental rights that was argued in this case was the law of privacy. They said the law of privacy, the right to privacy by an individual must be covered by right to life under Article 21 of the Indian Constitution. Now, implicitly what that meant was that any individual who is homosexual, if they engage in any consensual activity in the privacy of their own home and in their bedroom, that is their own business, and the government has no reason to interject in it if there is no cause for legal injury to another person that is recorded, and if the bodies of all the people involved are consensually involved. But this put the LGBTQIA community in a very twisted situation, because it's not that what they're doing is illegal, is just private. It just means they can't do it publicly, but it's illegal if they do it publicly. Luckily, during this proceeding came out, was going on another review petition which was filed by a very famous Bharatnatyam teacher and choreographer named Navtej Singh Johar, and an individual who happens to be gay themselves and is an LGBTQIA plus activist, in 2016. This time around, on 8th September 2018, the Supreme Court finally looked at this issue with the gravity that it deserved, and decided that it is against the fundamental rights of the LGBTQIA community to declare their lifestyle, which has nothing to do with anybody else or have any criminal implication if it's a consensual activity, and put homosexual acts outside the purview of Section 377 under unnatural offenses. Of course, this was supported by a lot of scientific claims and psychological data that suggested that there is no abnormality or dysfunction within being homosexual. The Indian Psychiatric Association accepted that homosexuality is not a disease in 2014. The American Psychiatric Association has declared the same since before DSM-3 was born, which is, I think, around 1970s. I'm not entirely sure. I'm pretty sure there is a citation about this in the previous episode about uses and abuses of history. And that brings us to the present day, where being a homosexual is no longer criminalized, which took an awful amount of time to get to for the Indian courts. And of course, the battle isn't over. The recognition of the integration of LGBTQIA community, which is argued for by Shakuntala Devi in 1977's book For the Indian Context, will not be complete until we recognize and completely integrate same-sex marriages within our legislation. Right now, marriages are between a biological man and a biological woman. There is no provision for adoption of children for LGBTQIA personnel except the transgendered individuals in Kerala and Tamil Nadu. The new surrogacy bill, or the Surrogacy Act, has also taken away the rights to have surrogate children for LGBTQIA couples. As of February 2021, there was a petition to ask for same-sex marriages for the community, but the court has stomped out the order, saying no fundamental right is being violated by lack of marriages, which is again debatable, but definitely it is an integration that would do no harm. The state sanction about this marriage will definitely bring about faster integration. It will bring about legal tolerance. It might even reduce the number of violent incidents, at least by the way of not letting violent sanctions by individuals be allowed or violence be justified, because there is a court backing with the community, which definitely matters. But essentially, that's how the rule of law works. You could be banging your head against a wall for a better part of 20 years. Not 20, but -4, which is 16 years. And all you could achieve is the right to say, I told you so, at the end of it. But essentially everything that Friedrich Nietzsche said about the conquering of truth holds true in the case of LGBTQIA plus community. And it took for them forever, by them I mean the society at large, that when a government comes to power that is incentivized by the constant production of population for a workforce, for consumers, for an economy, it sort of is incentivized that reproduction be carried out. And this is customary. At some point, just creating children is good for your species is a custom that has been followed since ages. It's not just new to the Indian government. It wasn't new when the British were here. It wasn't new when the Mughals were here. It was just something that we did since the beginning of time. And that's why we thought any reproductive act, any hedonistic pleasure that could be derived may not be good for the species. And then that prejudice subsisted by legal sanction, and how rule of law protected an entirely baseless argument for the longest time. which is why these checkpoints for autonomy need to be regulated and frequently updated with the latest knowledge that we have. And that's right, everyone. That's all I have for you this week. I hope you enjoyed that episode. If you did, please go to the YouTube channel and subscribe to the YouTube channel. It helps me gauge how many people are actively interested in being updated about a new episode. Please follow us on Instagram for the memes, and support me on Patreon if you think the content is worth it. Additionally, I have opened a Buy Me a Coffee account so that you could give me one-time donations for whatever you think the content is worth it. I think it's set at $2, but that's about rupees 150 if I'm not wrong. And just support the content is the request. Along with that, if you want to buy merch, there is an Instagram post linked down in the description, which could lead you to a bunch of t-shirts that we sell to raise money for the podcast. And take care. Once again, happy Pride, and I'll see you in a month, maybe. I don't know.